Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson. I'm joined today by Jennie Cluverius. She is a Maynard Nexsen labor and employment attorney out of our Greenville office. Hey, Jennie.
Hey, Tina. Happy to be here.
Glad you're here. And joining us also today is another Maynard Nexsen labor and employment lawyer, Bridget Blinn-Spears, and she practices in our Raleigh, North Carolina office, where she focuses on workforce investigations and employment-related litigation. So we're excited to have Bridget here to discuss employment issues related specifically to the construction industry. All employers have to deal with regulations, but construction in particular is particularly dangerous. Can you start, Bridget, by sharing some key regulations that construction companies should prioritize to stay compliant?
Sure. So I'm delighted to be here too. Thank you for having me on. So construction sites are particularly dangerous. And so for that reason, OSHA spends a lot of time focusing on construction sites. And so many of the key things are, when you think about kind of working your way around a construction site, there are regulations governing almost every aspect of those construction sites. So everything from fall protection and scaffolding. Scaffolding is there to keep employees safe. There are regulations governing it because if you set it up wrong, it can actually be more dangerous than not having it there. And then employees need to be tied off properly to avoid falling off the scaffolding or anything else high up that they're working on. It's also important to know what chemical hazards there are in your construction environment and to communicate to employees about those hazards so that they know what they are and what to do if something goes wrong with how those different chemicals are handled. And I think the other major thing is just protective equipment, that people know what regulatory requirements there are specific to whatever the hazards are on a particular construction site, and that at least the minimum protections are provided in terms of protective equipment. But many employees also want other protective equipment in terms of things like belts to help with lifting and various other kinds of, people like certain kinds of gloves because they feel safer in them. And so working with your employees to realize to get what they need in terms of what's required, and then also other things that individual employees might want to keep them safe is a good thing to do in addition to whatever the regulatory requirements are.
Bridget, you have a lot of experience in this area. One thing that I'm interested in what are the most common labor law compliance violations that you see being made by construction businesses, and how can they avoid those?
So I see violations in three big categories. The first one is OSHA, which we already talked about a little bit. And all of those categories that I just talked through are places that people get in trouble with OSHA, in addition to things that are specific to particular work sites. And so there's different hazards in different kinds of weather. And I know we're going to talk about the heat rule in a few minutes, but when it's particularly cold, particularly hot, or when there's severe weather, those are things that can also impact a work site and the ways that the workers need to be kept safe. And then the other two major categories that we run into are wage and hour violations. So people not being paid correctly in terms of both timekeeping and what time people are paid for, and which employees are treated as exempt from the overtime rules. And so there are really specific regulations governing who has to be paid overtime and who you don't have to pay overtime to. And a lot of times employers kind of have too high a level view of those regulations. And so they'll make mistakes and misclassify people and then end up owing overtime to people, which can double how much pay you owe people. So that's a really common violation as well. And then the other thing I run into really frequently with construction companies in terms of wage and hour is travel time. Where employers are pooling employees to drive to the work site together. And so one thing that they should know in terms of that is if you are having somebody pick a bunch of people up and drive them to the work site, if that person is hourly, they need to be paid for all of the time they're driving to and from the work site. Sometimes you need to pay the people in the car with them, and sometimes you don't, and there are regulations governing that. But anytime the people in that vehicle are talking about work, and planning for the day ahead or deconstructing, no pun intended, things that happened in the day before on the way home, that is also work time, particularly if a supervisor is involved and leading that discussion. So it's really important to understand what the rules are and to make sure that the supervisors who are riding in cars with people or trucks with people know what those rules are so that people are being paid for the time that they're actually working. And then the last one is the National Labor Relations Act, which many construction companies know about because they have organized workforces. So they have unions that they're engaged with. But the National Labor Relations Act applies to all employers, whether they have unions or not. And so where I see at least the most mistakes are on non-union websites, where employers are annoyed with people who are what they view as complaining about their conditions of their employment, or talking kind of coming collectively to talk to the employer together. But Section 7 of the NLRA does protect their right to do that, even if they're not in a union. And so that's important to keep in mind as well. That's also a common violation.
That's a very good point. And of course, under the new administration, with the, appointments that have been made and such, I think the NLRA is going to continue to be kind of front and center with respect to what employers are going to have to deal with.
Yes. And I think in particular, sort of the NLRA as it applies to all blue collar workers, that is a focus of this administration, that they want to make sure that people know that they're looking out for their rights in that way. And that's a particular worker friendly and maybe even an unusually worker friendly focus that we've seen in how the new administration is set up.
That's an excellent point.
And that's a great segue into talking about the new administration. You mentioned earlier about the OSHA heat safety rule. Can you talk about the potential rollback of that rule under the new administration?
Yes. So just for review, the heat safety rule applies when employees are exposed to temperatures of more than 90 degrees for more than 15 minutes in a 16-minute period, or in a 60-minute period. And it requires breaks, shade, and water. And so that's all pretty common sense in some ways. But the reason that rule went into effect is that not enough employers were providing those things, and we were having a high number of heat-related illnesses and injuries. So there's two important things to remember about this rule, even if it's rolled back. And so the first is that heat is dangerous. And so it's a hazard that employers must deal with their employees on their work site, either under the heat safety rule by doing what the rule requires, or under OSHA's general duty clause, which requires that employers furnish employees. I'm going to read this part so everybody has it top of mind, that employers must furnish employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. And so it's important to keep in mind most outdoor fatalities, more than half, occur in the first few days as the temperatures increase, because bodies build tolerance to heat over time, and also workers build habits over time. And so if you get dizzy once from not having enough water, you remember to drink water more after that. The process of building that tolerance is called heat acclimatization. And if you don't have that acclimatization on board, that's a big risk factor, not just for illness, but for fatal outcomes. And so employers, even if the heat safety rule is rolled back, particularly early in the hot season, should be paying attention to and training employees on how to pay attention to heat, how to prevent heat-based illnesses, those sorts of things. And so in the construction world, especially work outside, road work, roofing, those sorts of things are particularly prone to heat-related illness and injury. I actually worked as a lifeguard in Texas early in my career, and we had a concrete pool deck surrounded by brick walls on three sides. And every lifeguard except me was hospitalized with a heat-related illness over that summer. So it's not just construction that has this problem, but anytime people are outdoors without a lot of shade, you really do need to take rest breaks and drink cool water. And so providing that unlimited, easy access to cool water, having someone remind people to drink water, and monitoring that people do take breaks and are allowed to take unscheduled breaks if they start to feel any kind of heat problem is really important.
Bridget, which government agencies would you say are most likely to visit a construction site? And what advice do you have for employers when individuals from those agencies do come on site?
So the ones that I see coming on site the most often are OSHA, as we've discussed, and then the Department of Labor in terms of wage and hour complaints, or they're also allowed to do just audits. And so they'll come on site in connection with those audits. And then also Immigration and Customs Enforcement has been in the news a lot with visits to various businesses, and so employers need to be ready for that as well. And so each of those agencies kind of has a personality. And so they're investigators, sort of, we think of them differently, kind of in groups. groups, but the first thing to do is to remain calm. And so the way that we want to interact with the government is to be sort of friendly and neutral, cooperative, but not overly cooperative. And so we want to greet them, we want to welcome them, we want to ask if they have any kind of warrant with them. And then we want to assess whether we want to require a warrant or not. And so really the first thing you need to do after you've greeted the government and figured out why it's there is to call your lawyer and let them know that you're doing that and that you would like to have your lawyer involved in the visit. And then we are very prepared to scramble people quickly to get to either remotely or sometimes in person to come meet that government agent and help you with that, the beginning of that investigation. So most of the time they're going to start with an opening conference and tell you why they're there and what they want to look at. And they're often going to want to walk around. And so you're going to want to walk around with them and hopefully have a lawyer with you when you do that. And so the biggest thing really is to, for in terms of OSHA, if they point something out that you can fix on the fly, you're going to want to fix it on the fly. Or if they're taking a picture of something, you want to take a picture of something. And paying attention to the questions that they're asking and thinking about, okay, what's providing truthful answers to those questions, and where do we think they may be going with this so that we can try to contain whatever they're doing to the smallest possible sort of evaluation of your workplace. And really the biggest thing I find that makes a difference with that is the way that we engage with the investigators. So sometimes they come in with a really serious concern. If you've had a fatality on site and OSHA shows up because of that, all of the friendliness in the world is not going to make them any less hard-headed about what they're there to look at. But if somebody has a wage and hour complaint that the Department of Labor is not even sure is really a violation, and you're friendly with them and provide the information that they're looking for in a reasonably cooperative manner, that may be the end of it. But if you treat them poorly or you're too defensive and combative, they have the right to see all of your records for the last 3 years, and they may exercise that right, which sometimes you can't stop them from doing anyway. But sometimes a friendly, just cooperative way of behaving with them can really go a long way.
And Bridget, the construction industry is facing a bit of a labor shortage. Why do you think that is, and what can employers do to attract and retain talent?
So I know this is a kind of controversial piece of things, but I hear from my construction clients a lot that the focus on reducing immigration and people coming into the country to do jobs is definitely impacting the construction industry. And so is the immigrations and customs enforcement, both in terms of workers who are not documented, who may have had documentation that looked legitimate to employers when they brought them on board, or who have had family picked up in ICE enforcement actions, those sorts of things. So I think, that's part of why the labor shortage. And then we also just have had, the workforce is getting older. Construction is hard physical work in many instances. And there are other jobs that people can do remotely inside in the air conditioning that pay similar amounts of wages or sometimes more wages that also don't require a college degree. So I think there's just competition for those workers. And then what workers are available has also changed. And so I think in terms of, how employers can attract and retain new talent, your best people to do your recruiting, recruiters will tell you, is happy employees. So if people like where they work, then they tell their friends that they like where they work. And when their friends are complaining about wherever those friends work, often in the same industry, and you have openings, then those friends will come apply for your openings. And so when you're treating your employees fairly, when you're paying them fairly, I think that's a really hard thing for construction companies to figure out how to be profitable, to pay workers enough to come work for them and stay working for them, and then also to meet all of the materials costs, which have gone up considerably after the pandemic. And we'll see how the new tariff programs also affect that for construction employers. But paying people enough is really one of the main things that keeps them working for you. And so being really transparent about, here are our policies, here's when you're entitled to be paid, here's how we track the time that you're paid for, and listening to people when they say, look, the guy down the street is paying more than you are, and considering that in terms of, do you need to change how you're paying your workforce as well? So I think casting a wide net around where you're looking for people, encouraging your employees to look for people for you, paying bonuses. If somebody has somebody come work that's a friend of theirs and they work for their 90 days and they're working out, and then you pay a spot bonus for that, I think that really helps a lot with finding new people. Those are really some of the things that I see clients doing that seem to be working in this challenging environment.
Well, like they say about most communications, good news travels fast and bad news travels faster. So keep your employees happy so you can keep them around. That's very good advice, Bridget. Well, we have run out of time, but thank you for sharing with us what really matters in the construction industry. It seems like a very nuanced area of work. Thanks for sharing that with us. Thanks for that important information. Thank you, Jennie, for joining me today.
Good to be here.
We will see you next time on Work This Way.